Benjamin Bryant from Bryant McKinnon Lawyers here in Coffs Harbour, and today we are going to record episode 11 of our Family Matters Show podcast. You'll see us already a little differently. First of all, this is not Heather sitting next to me. This is Rhys O'Brien, who is a barrister, and we've pulled him from the courthouse just today to help us out with our podcast today. He's our expert. Thank you, Rhys, for being here.
My pleasure, Ben.
So what we're going to do is we're going to record the podcast obviously now, right today. It's not the first Tuesday of the month, which our loyal watchers would know. Today is, what is today? Wednesday.
Yeah. Wednesday, yeah.
It's a court week, so it's a bit crazy. It's Wednesday today, not the first week of the month either. So we're going to record it today. There will not be a show on the first Tuesday of March, as it ordinarily would be. We won't be recording that show. We're recording it right now, so that's cool. But it will be made available shortly on podcast or however you get it's available, however you get your podcast. So with that being said, are we ready to go?
We're ready.
Excellent. Welcome to episode 11 of the Family Matters Show podcast. I'm your host, Benjamin Bryant, an accredited family law specialist with Bryant McKinnon Lawyers. My partner Heather McKinnon is in court today, but we're very lucky to welcome our special guest, family law barrister Rhys O'Brien. Although he's based in Sydney at the prestigious Culwala Chambers, Rhys spends a lot of his time in courtrooms up and down the North Coast. And this week he has been in court in Coffs Harbour. We've persuaded him to come and talk to us between court sessions. Welcome, Rhys, and thank you so much for taking time to be on the show.
Thanks, Ben. It's great to be here.
Today, Rhys, we're going to be talking about a really interesting subject, and that is social media.
Indeed.
Facebook and Instagram might not be something you instantly associate with family law, but I can assure the listeners that what gets posted on social media can completely change how divorce and separation plays out at court. Rhys, I think we've both seen firsthand how one little Insta post can affect family court proceedings.
Mm-hmm.
And that's why we're so glad to have you today. So let's get started.
Let's do it.
The first question, Rhys, is all about how can social media be used in court proceedings. So can photos and videos from social media be used as evidence?
I think when you want to look at what court proceedings are, they are a forum where two parties, generally in respect of parenting matters, come together and present their evidence to the court about who is the better parent or who has the better life plan for their kids. In doing so, and in coming to that conclusion, we use evidence. So there's all sorts of pieces of evidence that are out there which can be utilised for and against a client.
Otherwise it's he said, she said.
Exactly right. So unfortunately, the court is hamstrung by seeing what evidence is before them and then seeing that evidence tested by cross-examination of that witness in the witness box. So in that context, photos and videos from social media can come into play because some people do very silly things. So for instance, I can think of examples. Would you like to hear examples?
We'd love to hear examples.
One example was there was a restraint on a party from bringing a child into contact with a particular person. In their affidavit evidence, they said, I haven't been bringing the child into contact with that particular person. But of course, lo and behold, there were some Facebook posts that were dated post the affidavit of that person being brought into contact with that child.
On a public forum?
On a public forum.
Wow.
So that then of course leaves the deponent of the affidavit, which is a technical term for the person who makes the affidavit, open to an attack on credit. And particularly in parenting proceedings, credit is actually quite important because the court needs to know that you're a safe pair of hands in respect of what you're proposing for that child.
And so, Rhys, from a family law lawyer or practitioner point of view, we know in the Federal Circuit Court at least, where most matters are heard, A lot of the time the decisions are made, or the matter is progressed on the documents, meaning there's not a lot of opportunity for the judge, for example, because people always come to me and say, I've taken this video, I've taken this audio recording, can we play it to the judge? And of course the answer is no, certainly in an interim setting. And so I'm sure litigants also are very used to, I think it's fair to say, seeing text messages or Facebook posts and the like attached to affidavits. But you're involved a lot at the pointy end when you get to the final hearing, where you do have the opportunity to get people in the witness box and cross-examine, and the judge is there to make a decision and, as you say, hear the evidence. How can a litigant or a party get a video essentially put before the court?
In terms of a video that they've taken on their phone, or a video that may have been posted up on social media?
Well, I should probably both, but let's go with on their phone.
Well, first of all, you'd need to assess whether the other person knew that was occurring, that they were being videoed, and also being recorded by way of audio recording. We're veering slightly off from social media, but what I would say is that there are certain laws in place that prohibit you from making recordings without a reasonable legal excuse. So you need to cross that first hurdle, and that's not the exact test, but I'm just trying to
summarise it,
water it down a bit. So you need to look at, well, have they broken the law? And if they have broken the law, do you then want to expose them to that criticism, and is the material that worthwhile that it would potentially still be admitted into the proceedings? Because the court has a discretion to allow evidence which is illegally or improperly obtained to be admitted.
If it's worth it.
Yeah, in effect, if it's worth it. If the probative value is the term, outweighs the prejudicial effect, and mostly it's always prejudicial, otherwise you wouldn't be seeking to have it entered into evidence. But if it's relevant and it's important, then you need to have a good hard think about whether you put that evidence before the court.
Okay. And if there was a video or there was a post of some sort on Facebook or Instagram or some other social media platform, and it may have been effectively removed or moved to a person where you don't have communication with, or something like that, however it works. Is it possible to issue a subpoena onto Facebook or Instagram or the like, for them to provide a recording or provide the post or something like that if you can't get it yourself?
I think the technical answer is yes, but the practical answer is no. So sure, you can try and issue a subpoena to that particular entity in whatever country it's operating out of, but that's one heck of a problematic thing to engage in, and can be quite expensive. So at the end of the day, you can say in theory yes, but practically no.
Okay. And you've given us an example before about just what damage social media can do to litigants in the litigation system. I just have some questions for you about the damage. Can you stop your ex-partner from making denigrating social media posts about you on social media?
I think technically, look, you can always go to the court and seek an injunction. In a scenario where there were children who had access to the Facebook page, which happens,
especially adolescents.
Yes, absolutely. Then you could say to the court, this is what's being put on there, the child has access to the Facebook posts, this has to stop. In those circumstances, I think you could get a restraint. But in circumstances where that wasn't the case, and they were just blowing off steam about their partner online, then it's not helpful and it's not good, and yes, you could definitely approach the court and ask that to stop. But the problem with family law is you need to take each case as it comes. And I would say yes, technically you could stop that, particularly in circumstances where you're involved in active proceedings, because it's likely going to be this has happened in court, or so-and-so said this, or the psychologist said this about them, and blah, blah, blah. Those sort of things they can't talk about. And those are the types of things which get spruiked on social media, because it's not just about the private war to them, it's about making the other partner look bad to their former circle of friends and family.
And I've said on this show many, many times that when a court is making an assessment, you mentioned before, parenting matters, on what are the future parenting arrangements for children, it has to take into account, or the primary goal is to make an order that is in the children's best interest. And a lot of people think that's a general kind of assessment, but it's not. Section 60C clearly sets out what things a court has to take into account when making an assessment as to what's in a child's best interest. So with that being said, in that context, if someone was to post something denigrating about their ex, or someone involved in the children's lives, how can that be used against them, especially in the context of that best interest assessment?
Well, again, it depends on what orders are being sought by either party. So what parenting regime you want in place for your child or children, and what parenting regime they're trying to put in place. So if they're making the case that they should have equal shared parental responsibility, per se, and they are consistently writing off the other parent publicly, that could, although that might not be the nail in the coffin on that argument, that certainly wouldn't be helpful for them when confronted in court with those documents, particularly if, and they can get quite savage towards the other partner, that would not be helpful for them and could be used against them in respect of their case. For instance, you could say, look, you don't have a very high opinion of the mother's parenting abilities or the father's parenting abilities, do you? And they might say, oh no, yes I do. And then you turn around and say, well, hang on a second.
Have a look at his Facebook
That's
post.
right, where you said all these horrible things about them and all these nasty things about their parenting capacities. Their capacity as a parent. Look, so you can get little small hits like that on people, and it's just not helpful for your case to be on social media posting about your case or the other party. We're in this culture where everyone seems to want to share too much on social media, and
well, it never actually happened if it's not shared on social media.
Yeah, maybe. And what you find is that people, when they're hurting and when they're stressed and anxious, as they are in family law proceedings, they go to social media and they want people to gather around them. They want people to know the injustices that they perceive have been inflicted upon them by the other spouse, and it's unhelpful. I would say it's unhelpful. I've seen many cases in family law proceedings where that's very much what people are doing. I remember one guy was going on a huge rant in respect of how he couldn't see his children, and he also included videos of him speaking to his children to show that he had such a great relationship with his kids to everyone. Now, of course, that was used against him. So my one comment before you get into specifics, I think my one comment with social media is that if you're in family law proceedings, don't post.
Yeah.
Don't post. Put your page on private. But also know that you have friends on your Facebook pages who are also still friends with your ex or the mother or father of your children.
6 degrees of separation.
And they will be spying on you, and they will be filtering that. They'll be taking photo screenshots, and they'll be sending it to the other person to be used against you. So I would keep yourself well away from social media in family law disputes, and to be honest, it's not an appropriate forum for you to be discussing these things.
Yeah, because I get asked a lot by clients whether they should delete their Facebook profile or their social media profile. I'm like, well, how much do you trust yourself? Can you control yourself? Is it possible? Because of course there's some really good things. There's some real great benefits of being able to use social media And especially in the context of families as well, if you have maybe families or friends over abroad, everyone's lives are getting more busy, just a single post can reach a lot of people, and it can be some really beautiful things and some communication. And of course, children themselves are communicating on the social media platforms as well, so there's some real benefits to them. We can't ignore the benefits, but yeah, you just have to be so careful.
I've just got an entire swag of examples I could roll out. Social media is something that people use as an evidence gathering tool. If you want to expose yourself to that, then by all means post to your heart's content. But if you want to run a bit more of a tight ship, knowing that you're in a season of
scrutiny.
Yep, that's a good way of putting it. I would avoid posting on social media in respect of your life in general.
And Reece, some people, we're talking about denigration, negative posts, but I know some people they feel quite strongly about any posts about children being on social media, whether it's denigrating or not. In fact, we're in court this weekend. I had a matter this week where we were discussing the digital footprint of a child, and essentially what we ended up doing, the matter settled by consent, which is great. But what we ended up doing was there was an injunction in respect to some social media platforms which one parent was content with, but not others. So some got specifically mentioned as an injunction: you cannot submit photos of the child on these particular ones, but it was silent on other ones. So there is this, I think, growing thing of trying to minimise a child's digital footprint. Of course, the child's only going to stay a child for so long; they're going to grow up and become adolescent.
That's right.
Next minute, they're going to have their own say on that. That's for sure. But is there a way that we can stop parents from, if that was put before a judge and the judge had to make a decision? Is there a way that we could stop parents from posting about their children or pictures of the children at all on social media? Is that a thing?
Never done it. I think it's interesting though, as you were speaking, thinking about this new dimension of parental dispute, that you have to actually have an argument in court about what gets posted online about your child. It's quite a remarkable thing to have an argument about. One would have thought that if one parent wasn't comfortable with images of the child being posted online, the other parent would just respect it.
But of course, the other parent's being unreasonable, Reece. You know that.
That's right, because they want to bless the world with pictures of their child, and why should they let the other parent stand in the way of that? Look, I think the technical answer is yes, you could stop them, but of course you could also argue against it and say, why do I need this restraint on me? I'm only posting up nice, wholesome pictures of my child. Of course, if they're putting up pictures of their adolescent child in the nude or something, then perhaps you'd have very strong grounds to have that behaviour stopped.
I'd imagine so.
And a few other orders put in place. I just, again, the technical answer is yes, you can, but it's always based on the actual circumstances of the case in family law. Because family law is broad.
And discretionary.
Yeah, and the judge has a discretion. I mean, you might come up against a judge who says, why are you even posting pictures of your kid online?
Yeah.
What's wrong with you?
Yeah.
And other judges might go, who cares? I post pictures of my grandchildren up on my private account with my family. So.
And Reece, we have a lot of situations where we have blended families, we have new partners, we have step parents and things. I imagine it would be harder to seek an order from the court, perhaps restraining them from posting something about the children or something denigrating about the other parent.
Well, you can't stop them because they're not a party. If they're a party, you could. If they're not a party to the proceedings, then the court can't make orders against them.
So that, and that's in an evidentiary sense. If we take on, that best interest principle and what you were saying before, in the sense of what the life is like for these children, what are the dynamics of the relationship with the people, with the children and their loved ones, and it might come to a point where, like you said before, mentioning the evidence of how a parent or a step-parent may be able to facilitate a meaningful relationship between the child and the other parent, or just, I think, as you said it, you don't prioritise their relationship, do you? If you got the step-parent in there bagging the other one out, certainly wouldn't help. No.
No, I don't think so. And look, again, it's the exact same principle. It can be used against you. And if you've got people posting on your page about the other parent, then you probably need to be seen to be shutting that down, because that will likely come back to bite you in the backside. Now, it might not lose your case, but it might not be helpful.
Yeah. When you're trying to get points on the board,
absolutely,
it's not going to help.
Well, look, I mean, when you come to family law, you need to be shown to be, and I say this in the most gender non-specific way I can, you need to be the white knight. So you need to be the good person who comes in saying, look, this is the best plan for the child or the children. This is how I'm engaging with the other parent to make that happen. Now we're no longer together. And all of these small things can add up against you to make you appear to be the less favourable option. So you need to think about that.
Yeah, to try and rise above the conflict.
Absolutely.
Yeah. And Reece, you mentioned this before, just briefly, and we're talking about social media posts and the like of denigration, and also the posts of children we've mentioned. But previously you also touched on about whether people actually mention their court proceedings or something published in the court proceedings. A lot of the time we have a lot of family reports, we have psychologist reports and the like. And you might have a post, you might come across a post that says, I knew the court psychologist was going to go say that, or I knew the judge was going to give them a serve or something. Why is it particular in those circumstances? Why is there a particular offence in that sense?
Well, you've got section 121 of the Family Law Act, which prohibits people from publishing the details of a party or publishing details that would enable the identification of a party to the public. So I'm sure everyone knows in your circle that you're going through family law disputes. Some might not. And by hopping online and publishing a post, which is what you're doing, you may well be falling foul of section 121, which is a criminal act.
And finally, Reece, I just want to end this on a positive note. What ways can social media be used in the context of family law, in a positive way? Have you seen it? Can you think of any examples whereby the social media is being used to prove that a parent is facilitating a relationship with the other parent rather than disproving it?
Social media. The only way that I would have seen that is via messaging. I have yet to come across a family law dispute where someone's been positive about the other on their social media. Happy to be proven wrong in the future, but I just haven't seen it yet. I think a positive way is, and a positive use of social media. It's a tough question.
Yeah, and you're always at the pointy end. You're at the acrimonious couple that absolutely can't reach an agreement, or absolutely cannot agree on each other's parenting styles, or that the other parents haven't got capacity sometimes to parent.
Because look, I've never seen a post, and I'd love to hear your opinion on this. I've never seen a post where they say, where they're in family law, where they're in a family law dispute, and they say, kids came back from spending time with the ex, they had a great time, I'm so thankful that they're in their children's lives. I have never seen that.
Yeah.
Now that might happen after the dispute, but it's not going to happen during the dispute, because of course people are in the scrutiny evidence gathering phase because they want to win.
Yeah. And of course, you wouldn't see it certainly,
Have
on your
you seen
level,
it? Have you
on
seen it?
an affidavit. I haven't seen it on an affidavit, no. But
You've seen it on social media?
I've seen it on I've seen social media used in really positive settings, not in an evidentiary sense, but on a broader family law context. Again, with, as I mentioned before, with especially communication with significant family members at a long distance. Okay.
That's right.
But not necessarily. As I said, you're in the box. You're in the mode with you've got competing proposals. This is the day before the judge. This is the evidence. This is your affidavit. This is confined to the dispute. So I appreciate that. It's a hard question for you to answer, because in those couples, like the 3% of people that actually need a decision from the judge, they're not posting positive things.
No,
they're simply not. So thanks for having a crack at answering that anyway.
That's all right. My pleasure.
Okay. And thank you so much, Reese, for taking the time out of your hectic schedule to be on today's program.
My pleasure.
And thank you to all our listeners. We hope you have found this podcast helpful, and that everyone out there involved in family law matters will now think carefully about their posts on social media. Next month, Heather and I are going to have a conversation about divorce and the blended family. When people separate, it's natural and healthy that they move on to new relationships. So it's not surprising that the number of blended and step families are rapidly increasing. New partners, new children, new families. All of these things can raise unexpected disputes or concerns between a couple that has separated or divorced. So Heather is back, and she's going to talk with me about when to expect concerns to arise, how best to handle them, and most importantly, what is best for your children. If you have a blended family situation and have questions that you would like Heather and I to answer, please send them via Facebook Messenger or email us on familymatters@bryantmckinnon.com.au. Before we go, I just want to mention that links to any resources mentioned on today's show, plus a full transcript, will be available in the show notes on our website, bryantmckinnon.com.au. Goodbye for now. Thank you for listening, and I hope you'll be with us next month.